Based in Larkspur, California, Stephen A. Nielsen is a U.S. registered patent attorney with many years of experience in patent procurement and in achieving favorable results in federal court in the field of intellectual property litigation. Mr. Nielsen is the past chairperson of the intellectual property section of the Marin County Bar Association. Mr. Nielsen received his JD in 1987 from Bolt Hall, University of California at Berkeley, and also holds a BA in computer science. He may be contacted at steve@nielsenpatents.com, on his website, nielsenpatents.com, or via his LinkedIn page.
Good afternoon. My name is Steve Nielsen, and I'd like to thank Bob for that very gracious and kind introduction. Today, we're going to talk about patent law basics and explore the mysterious world of patents, figure out what you can do, what you can't do, and just why patents are just sort of unknown by many people and just sort of treated as different animals, and sometimes for good reason. My name again is Stephen A. Nielsen. I practice out of Larkspur, California. If you Google Marin County Patent Attorney, you will find my website. And this is presented for the Center for Continuing Education, an organization that I've been involved with now for about 11 years. And their programs are first rate. Their prices are very reasonable, and I highly recommend their bundles, which are approved in Florida, of all things, since they have no real policies on exclusion based upon any criteria. So the goals of this presentation are to figure out what is a patent. We'll find it's different than a trademark or a copyright or a trade secret. And we'll find out what might be patentable in 2021. The law of what is patentable changes, I'll say, almost monthly. There's often a pendulum. Sometimes the patent office gets easier or more difficult in getting patents through the process. We're going to talk about important deadlines for filing patent documents. The deadlines both in this country and in other countries are very important, and you'll want to know these because my wild guess is that most of you out there are general practitioners, and you have clients who are what I call maybe gentlemen inventors, or clients who have great ideas, and they're going to come to you for guidance, and you want to tell them what the deadlines are if you know them, and then also confirm those in writing. We're also going to talk about what patent type work you may perform, and by you, I'm referring to the attorneys listening to this or here in the audience today, who are licensed to practice law in a state but are not registered patent attorneys, meaning they haven't taken the extra bar exam to sit for the patent licensure offered by the United States Patent and Trademark Office. And then we're going to talk about what patent works or patent punishment, as I call it, is reserved for just registered patent attorneys, people like me who have gone through the extra exams and extra science degrees. What is it that only we can do? It's good to know the differences so you don't get into hot water trying to do things that you aren't legally entitled to do. What is a patent? It's a piece of paper, and they vary from country to country. And in our country, I describe it as a state-sponsored license to exclude others from, in this country, importing into the United States or manufacturing or selling or using something in the United States. And what exactly are we talking about? What is patentable generally is a product, a machine, a composition of matter, a design or a plant. And more particularly, what's protected in a patent is what's described in the claims, and claims are always found at the end of the patent. So we're going to talk about that as well. We're also going to talk about the differences between what a patent is versus a trademark versus a copyright, and the terms of patents. As a general rubric in the world of intellectual property, the stronger the right, the shorter the period of protection, and patents are considered to be the strongest of rights providing a just flat out ban on the use or importation. And so its term is relatively short of about 20 years. Copyrights, on the other hand, are considered a weaker protection, and those are typically good for the life of the author plus 80 years or so via the Sony Bono bill passed a number of years ago. And then what's interesting is trademarks, if used and if the fees are paid, that protection can go on virtually forever. The best example being the Coca-Cola trade brand or trademark, probably one of the most valuable trademarks in the world. And then that's a good segue into describing the other component of intellectual property, which are trade secrets. And I like talking about the Coca-Cola case because the myth is that the recipe is hidden in a safe and only 3 executives have the combination. Of course, there's a bit of sophistry there since the ingredients of Coca-Cola are right on the label there. So that's sort of the 4 or 5 horsemen of intellectual property, patents being one of them. So when you talk about, some people talk about being an IP attorney, I always ask, well, what do you mean? Do you do patents or not? They say, well, no, you need a special license for that. The other forms of IP that we just discussed, you don't need a special license, just your law license will get you there. So we're going to talk about that as well. A patent is a right to exclude, which is different than a right to manufacture or sell the invention. And that's relevant because a lot of really interesting patents, and some that I've done, deal with chemicals or drugs or the world of 420. So looking at medical devices, for example, there are a lot of great patents for very intricate medical devices. It's a very profitable field for all involved. But having the patent on a medical device, or let's say a new drug, does not give you the right to sell or manufacture that product. For example, in medical devices or drugs, you may require approval from the Federal Drug Administration before you can sell. So there's a big, interesting dichotomy, a patent giving you the right to exclude, but not necessarily the right to make or sell the product. Also, a patent may give you the right to exclude someone if your invention deals with an improvement on a non-expired patent. Let's say there's a patent on 4 sets of wheels, and you have a patent, your own patent deals with an engine, some sort of motor, call it an electric motor, that uses the 4 sets of wheels. Well, then you wouldn't necessarily get to make your product using the 4 sets of wheels. You would need to buy a license from the patent holder if there's technology that you want to include in your invention. So you get maybe some cross-licensing issues, but the big point is that a lot of patents are incremental improvements, and where they rely upon patented technology where the patent is still in force, your client or the newer patent holder may need a license to execute their invention. The patent allows not only exclude others from making, but more importantly, excludes others from importing a covered product into this country. A lot of times I'll be asked, I'm sure you'll be asked too, is, do you need a patent in different countries? And the short answer is, if you want to protect this market, a US patent is very strong because it prevents others from importing into this country the covered item. And in this lecture, we're going to talk about the ability to file for patent protection in other countries, even using a priority date obtained in this country. And also the general rule, if you understand the rule, it's easy to remember the rule, but if you can just remember and understand that each country really defends its own sovereignty with great vigor. And each country wants to get its own fees for looking at patent applications, and each country wants to decide what's worthy of a patent. So if you keep that in mind, it's easy to remember there's no global patent. Although you can file documents that may be filed globally later, there's no global patent available. Again, your patent will also stop the domestic manufacture and sales we're talking about a US patent preventing others from this country making it here. That's easier to enforce because you can see what's being made here. So this is really interesting. Unlike a trademark or copyright, where you can figure out what's covered by the trademark or copyright, you can just read the copyrighted material, read the trademark, or in some copyrights are in music, so you can just listen to the copyrighted song. In the world of patents, it's far more intricate, far more complex, far more interesting. And a lot of clients, they'll come in, they'll do their own research of patents, and they'll come in with some patents that show maybe their invention or something very broad in the drawings or in the description. And they'll come in with angst and say, how can anybody get a patent on, let's say, the wheel? And what I'll tell them is that while wheels may be shown in the drawings or described, that's not what's excluded. What's excluded is found in the claims, which are found at the very end of the patent document, that specifically define the metes and bounds of the owner's right of exclusion. So what's really interesting is that the entire contents of a patent or published patent application can be used as prior art against someone who's attempting to get a current patent. But the coverage of that patent application or patent is again in the claims. Of course, for a published patent application, people forget that that's not a patent. That doesn't exclude anything. And it'll say published patent application on top. And that's just happens sometimes before a patent application becomes a patent. And it's also important to realize that not all patent applications become patents. Often, maybe 50% of the time for utility patents, a published patent application won't become a patent. The patent office will find that it's too vague, or there's prior art that consumes the claims, or that it's not original. And in some cases, it's just not useful. For example, if someone claims perpetual motion, unless you have a working model, the patent office, they're not going to be interested in even seeing that. So what might be patentable in 2021, 2022? It's got to be new, whatever you're trying to claim. And newness, we're talking about no public use or offer of sale more than a year before the initial filing. So what does that mean? Well, one, there can't be a prior disclosure in somebody else's published document. It could be something found in the Bible, in a magazine, so it's got to be new that way. And then the client himself has to file before he's publicly used or offered it for sale within a year. So if he offers it for sale, say 2 years ago, he's lost his rights to file for a patent application. And that rule makes sense, because if he's out selling this or offering it for sale, somebody looks it up, doesn't see a patent on it, they may think, oh, I'm able to make this themselves. So they've arguably reasonably relied to their detriment in making a product that they've seen published for more than a year. So, and also the patent office, a current theme through this presentation is very hungry for fees. So the patent office wants you to file early and often. So the first rubric is no public use offer for sale more than a year. And by newness, we're talking about can't be disclosed in writing, in a writing that's publicly available. Otherwise, it's not novel. And another thing about what's patentable is your own inventor has to invent it. You can't steal someone else's idea or invention or object and claim authorship of that. That's another reason why this country is now a first to file country. That changed about, I don't know, 7 years ago or so, in that whoever is first to file has rights over those who may file later. And the idea here was to get rid of some of our invention identity disputes as to who truly invented a certain product. The next rubric to look at is the product useful? And it's got to work, but it doesn't have to work perfectly. And the bar is very low for usefulness. The case on point has to do with an integrated circuit that somebody tried to patent. And it turned out the patent office figured it's not going to work. They saw some inconsistencies in just how the electrons flowed through the wires and the capacitor. Just people who specialize that this is not going to work. And so the applicant or inventor argued, well, it could be used for landfill, which is, I guess it could be, but the patent office drew the line there and said, no, your invention has to be more useful than landfill. So if it's a little bit better than landfill, if it just kind of sort of works a little bit, you're going to meet the utility usefulness of it. As far as utility goes, what's also interesting is if the patent office back in the old days used to require models of inventions. If you go to some of the older patent law firms, if they're still around, you go in the lobby there and you'll see these little models. They're about a foot, foot high, foot deep, foot wide, of little gadgets like the little steam engine going on there. And many, many years ago, the patent office got rid of the requirement for a physical model. And except if you claim, if an inventor claims perpetual motion, then just to see if it works or not, the patent office wants to see that. And of course, that stops a lot of applicants from filing patent applications for perpetual motion because they're not going to get a model to really meet those guidelines. Another important rubric in what is patentable is for it to be unobvious. And this comes in to what we call our 35 USC 103 rejections that we'll see, where the patent office will cobble together known components from prior pieces of known art and say it would have been obvious to one reasonably skilled in the art to have combined components from different gadgets to make the invention to achieve a known result. So a good example of this, let's say somebody invents something that uses a chronometer, wheels, gears, a photo sensor, known components. It comes up with something sort of new. The patent office can say, well, that's an obvious combination of known components, but there are ways to try to get around that rejection that we'll talk about in a little bit. The other hurdle in getting a patent is that the claimed invention needs to be a machine or a transformation in matter. And there's a famous case called Alice versus CSL Bank that says a mere algorithm or a method of doing something or just pure code going into a standard computer is not going to be patentable for the last few years, including 2021. So what the patent office is looking for is some tangible result, some change in matter to find that it's the right category. It's not just an ethereal thought. So the thought process isn't patentable. And in general, a pure idea is free as the wind and isn't patentable or protectable. So through the machine or transformation test, the patent office is attempting to sort of solidify that they're going to patent physical gadgets, which they love to deal with. So what is obvious? This gets into our 103 rejection of what's a known set of components. And the case law is in a state of flux. And what I tell inventors, there's no one book we can look up and see if you combine components, 1, 2, 3, and 4, is that obvious? No, we have to put on our own thinking caps and, like taking a good law school exam, apply the elements to the case at bar and analyze what the invention is. So the guidelines for obviousness is, it might be obvious if one reasonably skilled in the art would consider trying the proposed invention to achieve a known result. So I like the wheel analogy here. And let's say if we have a wheel, would it be obvious to add spokes to the wheel? Well, one could argue, well, probably, because maybe spokes are just a mere reduction of other components, revealing a spoke, because any wheel is going to have some centerpiece that hits the axle. So that's the kind of analysis that one does to figure out, is an invention an obvious combination of known components? Something might be deemed obvious if the invention claims a range or proportions of material that might be found by regular experimentation. And the best examples here would be, say, in cooking, although food recipes really aren't per se so patentable. But if you look on the figure on the left there, let's say you're trying to figure out how to get the chemicals right in your hot tub. And you try different combinations and you play with it for a while, and you come up with sort of the range of chemicals of, bromine and pH up and all those little things. The patent office might say, well, those proportions were probably found by a regular experimentation and produced the expected result. And thus, that's not going to be patentable. And on the right, we show somebody measuring something to show, well, if we take certain measurements of something, we're going to get there eventually. So that has been deemed to lack the requisite spark of genius or inventive concept. Something might be deemed obvious if changing the material of an object achieves expected results. And my favorite story here is, we know the pig and the wolf story, how we're going to have the first pig house made of straw that's easy to blow away. Maybe the next one's made of wood, easy to burn down. But then we have a house left made of brick, which is going to be harder to blow away or burn. And would a brick house be patentable to achieve the desired result of thwarting the efforts of a wolf? And probably not, because we can predict that the brick house isn't going to be easily blown or burned. And that also gets to an interesting idea of something being obvious or known in the prior art, because what about the composition of a brick? Could that be patentable? And in 2021, no, because there's a published description of that. It's something called the Bible. It's been around for many, many years, where they talk about making brick from clay and straw. So that fabrication of brick isn't patentable because it's been publicly disclosed in a piece of publicly available literature, and publicly what we would call as non-patent literature. So the Bible isn't a patent document, but we have magazines, news articles, trade journals, which are called non-patent literature. Patent literature being patents and published patent applications. So if the object's been described in those writings, such as the brick here, not only is the brick going to be obvious, but it isn't patentable because it's been described so long in non-patent literature. Something isn't obvious if unexpected results are achieved. So what's wonderful is often inventors will work in the lab and something unexpected occurs, and that's what becomes patentable. I think a lot of drugs and things were found just through happenstance for certain uses. And the cleanest and best use of something that worked for an unexpected result, it's aspirin. Let's stay there. Somehow someone figured out that the use of aspirin reduces the incidence and severity of a heart attack. And what's interesting, when this was discovered, I don't know, maybe 20 or 30 years ago, the original for patent for aspirin expired over 100 years ago, but this new use was considered unobvious and the patent was granted. So what happened then is someone got the patent for using aspirin for heart attacks, and how exactly that's enforced, I'm not sure. But what it shows is that you have a new, unexpected, unobvious use for a patented product. You can get a patent for its new use if it's novel and not obvious. Something isn't obvious if the prior art teaches away from the invention. And sometimes you'll actually see it. I've had some case involving cell phone technology used to figure out if produce is going to work or not, using various bands of light frequency. And that's sort of been a holy grail. And there's been articles written saying it has to be done with certain gradients, teaching away. from what later became patented. So it sounds like a rare event, but this does happen. So if the client is well versed in the prior art and can come up with prior that teaches away from what he or she is trying to do, that goes a long way in getting a patent application through the patent office. So it's always good to talk to clients, see what do they know, and why is this novel, and do others say it can't be done? If you have that in writing, it's very, very helpful. And a danger, as for you non-patent lawyers and talking to these inventors, is you may want to figure out rather quickly if you want to help them or not, because the inventors, they're passionate about their inventions, and they will talk to you for the rest of your day if you let them. So you have to engage in some time management skills. And I believe CCC has some excellent videos on time management and drawing personal boundaries on the length of meetings. So let's get back to what is patentable subject matter. As we might have mentioned before, thoughts, pure ideas, and mental processes are not patentable. A good example is we've all gone to a stockbroker's office. They say, buy low, sell high. That's an ethereal mental process. You're not going to get a patent for that. And then on the right, we have sort of some graphs and just some general ideas of economics. Those are very difficult to patent as well. So to obtain a patent, the client needs to show a change in physical matter, computer information within a standard computer without a physical result is pretty much not patentable. The seminal case on this is Alice versus CSL Bank. But what's interesting is there's a lot of good patents on visual displays. For some reason, the patent office finds that they meet the requisite physical element test. And what's really interesting, there's some really good icon patents by Apple Computer and other computer companies for their icons. And those are typically take the form of a design patent application. And design patents are relatively easy to obtain. And in some cases, they can just be two-dimensional, being an icon on a computer or a graphical display on a computer. And what's really interesting is they can be two-dimensional, and that they can be for like a motorcycle jacket or a workout towel, where you just show the seams. You don't have to show the depth of it, just the height and width. Most design patents, you're going to have to show all 6 sides of it. Imagine a piece of paper having 6 sides and then a perspective view. So patentable subject matter also includes artful industrial designs. So in summary, what's patentable in 2021? Gadgets and mechanical devices, a good chance. Electrical circuits, as long as they work somewhat and are more useful than landfill, as we just discussed before. And then the industrial designs, if they contain optional ornamental shapes, those can be very patentable and often very valuable. For example, I have some in plumbing products, of all things, where there's some interesting shapes, and also toys for bats and balls, where there's some discretionary shapes, and those become design patents. And what's really interesting is sometimes, for example, there may be a design patent for the golden arches of McDonald's, and let's say a design patent lasts 17 or 14 years after it's issued, and it might go away. But what happens with, say, the golden arches is they then bleed into what's known as a trade dress, or they become a source identifier and become a trademark, which, as we mentioned earlier, the Coca-Cola example, can go on forever. So there is some crossover between design patents that become source identifiers and then become trade dress registrations under the trademark rubric and last forever. So that's one way in which the term of a design patent can be expanded on to infinity if that design becomes so iconic and identified with a particular manufacturer or company. And the golden arches are the best ones. I'm sure we can think of other ones here. If anybody thinks one, just raise your hand and you can shout that out later. With patentability, small steps are allowed. For example, It may be an improvement to an existing item, such as a Mercedes-Benz engine or piston system, and also what Mercedes-Benz is known for. They have over 10,000 patents. A lot of those are for incremental improvements for the airbag. They claim to be the first to invent an airbag. Who knows the truth there? But they like to do incremental patents, and you'll have certain clients that are just have great passion for patents, and they'll patent just the smallest increments just because they want to protect what they can with that. So here we have a couple of pictures of some of my favorite Mercedes product, the first being the Pope Mobile. So we'll leave that alone, and then the gull wing doors on the SL model. And what's interesting is that even though Mercedes has a lot of patents on their engines, they've been getting patents, I think, since the 1890s. And this became apparent for a local inventor here in San Anselmo who had a piston that he wanted to patent, and the prior art cited came from Mercedes-Benz, and his drawing sort of looked like this. And you can see here references cited. This one by Dahlmer, that's the old name for Mercedes-Benz back in the 1800s, was used against us. So we had to go back and show how this particular piston and input-output system of feeding the piston, getting the air and fluid in and out and through the exhaust and input was different going back to the 1800s through a Mercedes-Benz patent. So it was a small increment, but it was enough to get around some prior art that went way back. So clients are always amused that expired patents can be used as prior art against their own invention. And what's interesting, we have a lot of amazing inventors here in California and in my hometown here of Marin County, and this is one of them. And also, non-complex items can be patentable. I'm most proud of my portfolio of very simple mechanical items with virtually no moving parts. They take the most work. They are not inexpensive to obtain. If I have a complicated chair or something with a zillion moving parts, or a medical device with a lot of moving parts, they're easier to patent because you can just look at the complexity of the movements and the interaction of a lot of moving parts, and odds are nothing's going to be like it. And your patent is easier to obtain than something with no moving parts, such as this interesting line badge identification system by a local inventor here. And this is pretty much what it is. You have these different attachments that go to the front or back of a bottle of wine, and then you have these little cards you fill out, you write it out, you stick it in the attachment either in the front or the back here, and that was the patent, and that was enough. Of course, we described the nuances in some pretty good detail and made arguments on how these means of attachments were different, but looking at it, it looks pretty simple. So that was a fun result, and so sometimes it's just surprising of the simplicity of objects that get through it. One can argue that they aren't obvious. Also, what's really interesting is that people in other countries are allowed to file for patent applications in this country. So here we have a patent I obtained for a ball throwing machine. The inventors were based out of Australia. They had filed in their own country and then filed something under the Patent Cooperation Treaty, which extended their time frame to file in this country. So I was able to take that PCT application, file it within 30 months of the earliest claimed priority date, and get the patent here in this country. And so what's interesting, people think you have to have certain qualifications. In the patent office, they'll take anybody's money to file an application in this country. In fact, even prisoners, the people in jail, can file for patent applications. The patent office, they don't care, and people can be of any age, from 2 years old to 200 years old, and file for patent applications. So what's interesting is that a lot of people in other countries find this to be an amazing market. I'm talking about this country of the United States. So we'll have a lot of patent holders, either corporations or individuals from other countries. And this one was for a very interesting ball throwing machine with all kinds of gears and different spinning devices to give all kinds of curvatures or curves or spins to a ball being thrown out. So AU is my abbreviation for Australia. And then as to the simplicity, in Marin here, we have a lot of golfers. And we have a lot of golf-related inventions. Some are complex and some are very simple. Here's one I'm very proud of. That's a golf swing guide that comprises sort of this triangular elongated piece that you put on the ground and you put the ball near it. And if you're banging your club against this piece here, then you know your swing is off. And the idea is to use this guide here. You put the ball near it, you hit the ball, not the guide, your swing is improving. So that was enough utility to get through to the patent office. Also, design patents, as we mentioned before, are very popular. The terms can be around 14 years, sometimes 17 in the old days. And they can be, the inventors can be out of any country. Here we have a lady out of South Africa who's known for her interesting hairband, hair clip designs that she does. And so this is the hair clip, and we have the interesting sort of bead collection here going on. So the actual comb here part may not be so patentable. That looks like it's been done. And sometimes if we have a known item or prior art item, we'll draw it in dashed lines to disclaim that part of the design, leaving, in this case, the beads in solid lines to say, this is what we're claiming, this interesting bead pattern in the concept of a hair clip or something that people typically put in their hair to hold their hair together. So here we have an interesting example of a design patent and someone from South Africa filing in this country to get this interesting hair clip item protected here. And maybe this inventor comes to trade shows in this country and doesn't want to see her hair clips on the tables of other exhibitors. Off the golf course, design patents can have a wide breadth and can be for clothing items, very simple clothing items. So here we have a local inventor who has his own line of fashion for bras, panties, all kinds of different clothes. And this is just a small sample here. So here he has some underwear design patents out of San Francisco where he has a design patent. Before undertaking the patent process, it's a good idea, but not required, to commission a search for prior art. What's interesting, in this country, there's no requirement, but to the extent an inventor or the inventor's attorney or anyone material to the prosecution of a patent knows of prior art that's in the field or would be considered material to a patent examiner, that person is required to disclose that known prior art in the patent application. And if during prosecution of the patent application, someone becomes in the chain of obtaining the patent, becomes aware of relevant prior art, they're required to do a subsequent disclosure to the patent office, bringing to their attention some prior art that could potentially vitiate or destroy the patent application, sort of a self-policing policy. But this does come up in patent litigation if discovery shows that an inventor knew of prior art and didn't disclose it to the patent office. That can be deemed a fraud against the patent office. And then all the work and expense to get that patent goes out the window. And it's quite embarrassing for all involved. So some inventors have the idea, well, I don't want to search because I have to disclose it. Also, a search is no guarantee that all the prior art is going to be found. The other issue that comes up is that in the world of patent literature, either patents or published patent applications, those typically aren't going to surface until 18 months until after they're filed. So if the client's priority date is sometime back, let's say it's 8 months back, it's possible that somebody with an earlier priority date, say 15 months back, filed something, and it doesn't pop up until after you've done your search. So here you have a real problem. You have a piece of prior art with an earlier priority date going back to, at the time you see it, 18 months, it pops up. The clients come to you within 9 months, so their priority date is sooner, and you've got this piece of prior art sitting there looking at you, and if you find it, you have to disclose it to the patent office. So the relevance is that an encouraging search for prior art doesn't guarantee that a patent's going to issue, because one, whoever does the search can't find everything. Carl Sagan used to say it's very difficult to prove a negative in the universe, and I wholeheartedly agree with that. So no patent attorney or search firm is going to guarantee finding all relevant patent prior art, because also what is deemed relevant by one person may not be seen as relevant by the person doing the searching for prior art. So, but the bigger point here is that an invention must be new and not described in any previous writing that is publicly available. And we discussed this earlier with the straw and the clay disclosed in the Bible as a way of making bricks. Ergo, if somebody wants a patent making bricks by straw and clay today, it's not going to happen because of the prior publicly available writing that describes that process. Important deadlines. As we mentioned before, we have a 1-year bar on sale in this country, and I think other countries as well. In fact, other countries have what's known as absolute novelty, meaning you need to file before you publicly disclose. Or sometimes in design patents in China, you want to file within 6 months of your first public disclosure. So someone in this country needs to file a provisional or non-provisional application within 1 year of the first public use, public disclosure, or offer of sale. So you can make a sort of a private offer of sale. Even though it's private, it starts that time bomb running there. We show our guy there in the with the hat with the time bomb running around there. That is bad news. So you always want to, in any communication with the potential inventor, just tell them there are deadlines. You talk to perhaps a registered patent attorney for more information, but in general, you need to file within 1 year, before your first offer of sale or public use or public disclosure. Important deadlines around the world. We talked about the PCT application earlier with that ball machine out of Australia. So what that means is that in other countries or in this country, we can file a PCT application within 1 year of our earliest claim priority, which is often a provisional patent application, which lasts for a year, gets a client to patent pending status, and can be used as the priority date for a PCT application. The PCT application allows someone to file in other countries, such as in this country, within 30 months of their earliest claim priority date. So that's a lot of concepts. So the big picture is some clients will be on a budget. They don't know if their patent's going to sell or their product's going to sell or not. They file a provisional, which is less expensive, gets them to patent pending, gives them a priority date that can be used in a full non-provisional if that full non-provisional is filed within a year, but also the provisional gives you fodder or a priority date for the PCT application that gives you an additional 18 months from your 12 months given to you in the provisional. So again, the bigger picture is a lot of people, they'll file the full non-provisional, the provisional, and then they'll file the PCT application if they want to extend the time to file in other countries, because the other countries could have, often have, the 1 year rule as well. So people spend a lot of money on a PCT application, which doesn't become a patent anywhere until that's filed at a national stage in a different country. Again, referring back to the PCT filed out of Australia, ended up being a patent first in Australia and then in this country as well. So as a non-patent attorney, and there's many in the audience here, what patent work or patent punishment can you perform legally? The good news is one of the most profitable aspects of the patent world is in patent litigation. A lot of numbers, a lot of money changes hands. If you read Law 360 every day, there's always a patent case with some astronomical judgment won or defended against. And you don't have to be a registered patent attorney to engage in patent litigation. And what's good, I think, with the world of patents is that a good patent describes a technology such that the average person can read it and understand what it is, which also means that a non-patent attorney can read a patent and maybe hire an expert for a little tutorial and can be more than competent to litigate the heck out of pretty much any patent. Maybe some exceptions in bio and pharmaceuticals. Some of those patents are difficult to do for those who don't have a background, but simple electrical, mechanical patents, software patents are pretty understandable to the average person if you have a good expert to help you figure out. A good analogy, there's a lot of really excellent construction defect lawyers dealing with condominium units gone bad, single family homes, large buildings gone bad, and the concepts are relatively simple. And if a construction defect lawyer hires a good soil expert or structural engineer, the concepts can be explained so they can go litigate those cases, and patent cases are pretty much the same. Also, with respect to patent litigation, a great place to start is in the local patent rules. Here in the Northern District in San Francisco, we have a very active patent litigation schedule, and our local patent rules are in constant refinement, and they give an excellent roadmap that most of the judges follow down to the day as far as what events are going to occur and the spacing of those events. And a lot of the initial case management statements pretty much just adopt the local patent rules with a few of the dates adjusted to comport with various holidays. So anyone who wants to do patent litigation, I'd recommend it. It's interesting, it's fast paced. A lot of interesting technology occurs. The inventors are interesting to deal with. And the local patent rules really give a great roadmap on how it's conducted. What else can a non-registered patent attorney do? And one of those fields is in patent license agreements. They're animals of contract, and it's one of the few practice books that I keep current. And that what's interesting about it, I find, is that there's about 19 or so categories to your typical patent license agreement, and these are in the books. And then out of those 19 or so categories, there's maybe 4 to 12 different ways to go in each category. So, I mean, the combination is is a very large number, but you can, if you just start with each category, look at the 5 or 6 options, you can pretty much anybody can get through and draft a very competent patent license agreement. And if you do enough of these, you'll find yourself answering the same question over and over. Inventors want to know, how do I know I'm not getting ripped off? And then you go to the accounting clauses in these agreements that deal with that very subject. The unregistered patent attorneys, and we're going to talk about how one becomes registered, may not draft or file patent applications in this country, and may not draft or file PCT applications, and may not represent others before the United States Patent and Trademark Office on the patent side. Now, the unregistered may assist in the other elements of what we call IP law. So unregistered can help people with trademarks, copyrights, trade dress, the area of trade secrets, and litigate those as well. So only it's the drafting of these sacred patent applications that aren't allowed to be dealt with by non-patent attorneys. And so the next question is, how does one become a registered patent attorney? I get this question all the time. In fact, I see it in the chat box right here, so I'll address that. What's really interesting is that practitioners in trademarks and bankruptcy and other fairly esoteric specialized areas don't need to take a special bar exam and don't have special exams. They may need exams and requirements to become a certified specialist in those areas, but the mere practice of, say, tax law and bankruptcy, insurance coverage, other areas I find to be very complex, don't need the special license. For some reason, the world of patents has arisen, and there's a special bar for us. What's really interesting, the world of patents really originates in the Constitution. There's a clause there. It says, in order to promote the science and arts, the government may enact laws granting inventors limited monopolies to their inventions. The idea is if someone has a state-sponsored monopoly, a right to exclude others, it'll encourage a lot of horrific research and development in that area. Of course, contrast that with some recent thoughts about not granting patents for COVID vaccines. So there's a tension between public safety and attention and encouraging others to invest millions of dollars, if not more, to find a new vaccine or to develop a new drug or to develop a new process. So to become a registered patent attorney, one has to have a degree in a hard science. Unfortunately, political science doesn't count. Most of us have degrees in political science. So one needs a hard science degree and physics, mechanical engineering, electrical engineering. What's interesting is that a degree in math doesn't qualify one to sit for the patent bar. And then the patent bar itself deals with a lot of esoteric rules of patent law, but also just how to navigate within the ecosystem of the patent office, because the patent office has us registered patent attorneys upload documents into their database. And we have special dual encryption keys with all kinds of security, so only we get to do this. And the patent office doesn't want to see a bunch of cowboys misfiling things in their well-oiled system. So that's another reason why they require a special exam for attorneys to represent others before the patent office. But in contrast, the patent office does allow inventors to represent themselves, just as in a court of law, an individual, if they so choose, can represent themselves. You can't represent others unlicensed, but if you're up on in a civil case, you can represent yourself. What's interesting, though, is that a corporation needs an attorney, and someone, if you want to represent someone else for the patent bar, that person has to be a registered patent practitioner and take the exam, have the degree in science before they can represent others in drafting patent applications, and which that exceeds the scope of what we're going to talk about today. Another important item to tell your clients when they ask about patents and how it's done, probably if you're not registered, you're going to go through your local bar association, find your local registered patent attorney and send that referral to him or her. But the client will ask, is this going to make money? And my response is that attorneys are terrible judges of what makes money. We're bad with money, and hence we don't retire until we're 80 years old. And we could predict if we were good with money, we wouldn't be working, talking to you. Sometimes I actually say that to clients. The other important aspect for the generalist to know when they have a client who's interested in inventing and promoting their invention and monetizing their invention is they'll see ads on TV, such as Invent Help and others, and they're welcome to sue me if they want, because what I say here is true, is they are very skilled at separating an inventor from their money. And I've had many experiences, and in my humble opinion here, they have not provided services commensurate with the fees that they have charged. In fact, they're known for being so heinous against inventors. We have the American Invent Act, and we have on the Patent Office website, there's a complaint area where where inventors can write complaints against these invention promotion companies. The invention promotion company has so long to respond. Often they don't. So there's a whole cottage industry that's been going on for over 50 years of appealing to inventors, telling them this is the best invention they've seen, The invention promotion company will then sell them services such as drafting pictures, product development, CAD drawings, making prototypes, and then purportedly marketing the invention. And what's really heinous is they'll also offer patent services. So what they'll do is I've seen some invention promotion companies, small ones, not the ones you see on TV, but much smaller ones, actually sort of draft a patent application for a client and then have their client or the inventor file that themselves. And then what often happens is there's an office action rejection. The patent office says no patent for you. And then they'll come to a registered patent attorney such as myself, and I've seen these myself. And I'll say, who drafted this? And they'll say, oh, my industrial designer down the road. And I'll say, well, he's not licensed. Well, I didn't know. I just paid him some money. He gave this to me and told me to file it. And there you go. So you want to inform your clients to be very careful as to who they hire to draft the patent applications, because it's a very specialized type of document. The rules are inherently complex. The rules for the types of drawings that go in, the written description, the abstract, and the claims are where every word truly counts. So everything's got to be just right to get a patent application through the patent office. So warn your clients to beware of invention promotion companies, beware of industrial designers who will build prototypes and then claim to market the invention. And sometimes the invention promotion companies have very fraudulent fee agreements. I've seen this, where it looks like you get, design a prototype marketing for a certain price, and then you dig deeper in this horrific contract, and you find out, no, that's just one phase. You get some drawings for $10,000. Another 10, maybe you get a prototype, and another 10, maybe you get some marketing, but it's not apparent. And then when you go to a client goes into small claims court to complain, a lot of the small claims court judges just say, well, let's look at the four corners of the contract and say, shame on you, unsophisticated inventor. You should have read the entire contract before signing. And the client or the inventor says, well, I trusted what was told to me by the telemarketer. And the small claims judge will say, well, too bad. It's the contents of the contract that govern. So that's the unfortunate experience that a lot of solo inventors are going to find when they try to promote this. So as you, in your practice as generalists, which I see mostly in this audience here, I would advise clients to stay away from invention promotion companies, be very careful of industrial designers who will work with your client, help them come up with ideas, and then out of the blue, claim to be a co-inventor. And this bites a lot of unsophisticated first-time inventors. They pay a lot of money to an industrial designer who maybe comes up with a few concepts, and the industrial designer says, hey, I now own this invention, I'm a co-inventor. The way to avoid that is to have the industrial designer or anyone who your client hires sign an assignment of any and all patent rights, so that while the industrial designer, maybe he or she actually is an inventor, maybe they did come up with some inventive concept that ends up in the claims, the point is that you would have the industrial designer sign an assignment in the patent application, giving your client the rights to the invention. But that starts on day 0 when your client hires the industrial designer to have the industrial designer sign for the work for hire agreement, where the industrial designer agrees that any patents the industrial designer will sign later patent assignments, and also giving your client all the rights to the IP, including the source file, sort of the .step files for any drawings. I've seen cases where the industrial designer does some work and the client says, okay, I want the source files, and the industrial designer says no. Just like some photographers, if you're not careful, will take your picture and then give you some proof. You'll say, well, gee, I want to get the original negative, or the dating myself, we don't have negatives, but the original JPEG or the digital file of the picture, so I can put it on my website, et cetera. And the photographer said, no, you didn't buy those rights. You should have looked at the fee agreement. I own the original content, even though it's a picture of you. So those are the pitfalls that you may want to warn your clients about if they think they're inventors or are interested in filing for patent applications. And the good news is, if you can do patent litigation, you can do their patent license agreements, you can certainly form their various corporations that are going to sell the products, but the actual drafting or prosecution of the patent application, only a licensed patent practitioner or registered patent attorney can do that. And if you have any questions on this, I'm very easy to find and to communicate with. If you Google Stephen A. Nielsen, Marin County Patent Attorney, or sometimes just Marin County Patent Attorney, you will find me. My website is nielsenpatents.com, and that's the Danish spelling of Nielsen and the word patents, patents.com. My phone number's publicly available, and my email address is there. And I do have a LinkedIn account where you can see some of my work samples, and my website has a few work samples as well, along with my contact information. And I'd be happy to answer any questions now or offline. If there's any questions on what you can do, what you can't do, and what are the patent basics that you want to know so that you can speak intelligently. And when it comes to patent basics, you will inevitably find a misuse of the words, even by learned attorneys who aren't registered patent attorneys or who don't do trademarks or copyrights as a specialty. You'll say, gee, I want to patent a copyright, or I want to patent a book, where the correct nomenclature might be, I want to get a copyright for a book. And also, as to the referral of trademarks and copyrights, unless you've done a lot of it, I would recommend referring that work out to those who specialize in copyrights or trademarks. That's what I do. Although I'm qualified technically to file copyrights or trademarks, I don't, because the world of patents has enough complexity to me that it keeps my mind fully engaged. And I personally have no desire to learn the whole trademark side or the copyright side of the U.S. Patent and Trademark Office. Thank you very much for your attention here. If you have any questions now or later, do let me know. And I appreciate your interest in this. And hopefully some of the mysticism of patents has been diminished for you, and you won't be afraid to at least talk about the concept of patent prosecution, which is really a fancy word for saying patent procurement, which really arises from fighting back and forth with the patent office and the patent examiners, who are hardworking people doing the best they can with very limited resources and limited amounts of time. Thank you again for your interest, and do contact me with any comments or questions.